sorry you ever tried that. All that stuff is in the materials in any event. We're going to get started if we could, please. Anybody who attends the 6-Minute Real Estate Lawyer knows Craig Carter, not because of anything that he ever says in these programs, but because he's the guy with that little egg that rings every 6 minutes or whatever, annoys the heck out of everybody who's a speaker. He gets 25 minutes, and I'm going to annoy him every 6 minutes, just letting him know where he is by ringing a bell or something like that. Craig is going to talk about easements. It sounds like it's esoteric, but easements are constantly a headache when it comes to our titles, and Craig is going to Craig is going to shed some light on easements for us.
Thank you. Nice to see everybody here. Easement topic, one might think is could be tedious and boring, and you're right, it could be. I was in the dentist chair this morning getting my first filling done in 45 years, and as I was getting ready to be drilled, I was thinking about this program, and I was thinking easements, drilling by a dentist, what would people prefer? So my dentist gave me some business cards to hand out later. So I'm going to, I can't cover everything in the paper, obviously. There's some good practical stuff in there. What I'm going to do is try to talk about a couple of topics. I'm going to try to talk about the Ellenberg Park case, which is the main easement case, because everybody should know its existence, and it's a fun case. I'm going to talk a little bit about this notice of claim and the 40-year rule and whether you lose your easements or not. I'm going to talk a little bit about positive covenants, which is a very interesting issue in relation to easements. So to start with, and this is really basic, but everybody needs to know this, and I can tell you that I often still get them mixed up, the dominant and the servient tenement. The dominant tenement is the one that gets the benefit of the easement. The servient tenement is the one over which the easement goes, okay? So you've got to memorize that and keep that in mind, or everything gets very confusing. Okay, so why do we care about easements? Why are easements so important? And when I do the Ellenberg Park case, I'm going to talk about the 4 characteristics of an easement that you have to have in order for the right to use property to be considered an easement. But why does it matter if those 4 rights are not there? Or why does it matter if whatever right you're getting is not an easement? And this goes back to really basic land law and contract law. And that is that only interests in land go with the land. So if you have a contractual right to use somebody's property, I give you a right to use my property, that does not run with the land necessarily. And if it doesn't run with the land, what happens? Well, if it doesn't run with the land, then if somebody buys the dominant tenement, they don't get the benefit of that right. And if you sell a servient tenement, the person buying it isn't bound by that right. So it's really important that whatever right or use is being given over the land, that it be characterized as an easement if you want that thing to survive transfers of the dominant and the servient tenement. And a lease is to be juxtaposed to the other right, which is a license. Now, a license is a personal right that doesn't necessarily run with the land. And the other factor about a license is they're generally terminable on reasonable notice, where an easement isn't terminable on reasonable notice. The other things that can be juxtaposed to an easement is a lease of an interest in land. Leases actually are treated the same way as easements in that they run with the land, privity of estate, and whether or not they're assigned to the new acquirer of the property of the tenancy, they still bind the reversion. So they're treated in the same way as easements. And this was because the old law said it's really unfair if you get a lease or an easement or a right to use land that ought to bind subsequent purchasers or acquirers. The law said, how can we get around that? How can we we make sure that they do bind. And so they came up with this concept of an interest in land. In the case of lease, it's a leasehold interest. In the case of an easement is an interest in land. I'll talk about it in a little later, but this concept of positive and negative covenants is also a basic contractual issue, and it comes up in where in easement law it binds the land. Positive covenants, contractual covenants, do not bind the land. They're personal to the parties who entered into them, unless you have an assumption agreement. So privative contract says only the parties to that contractual right are bound by those rights. And where you get some interesting issues in easement law is the easement grants an interest in land, and then it has a whole series of positive covenants. You know, you will pay for your share of the driveway, et cetera, et cetera. Well, those positive covenants may not be enforceable against a subsequent owner, even though the easement is still valid as against a subsequent owner. So that creates a real mess in law in how you deal with these things, and I'll talk about that a little later. The other thing to remember just in this positive covenant, this contractual area, is that actual notice and registration of these non-easement rights, contractual rights, is irrelevant. So if you have, let's say you have a document that grants a right, and it's in the nature of a license, does not have the characteristics of an easement, and you somehow put it on title to the property, that doesn't bind the subsequent owners because it's not an interest in land. And that's why it's really important when you're giving these rights to think through the issue of, will this bind subsequent acquirers of the servient tenement, and will subsequent acquirers of the dominant tenement get the benefit of this right? It's really critical. And that's why I'm going to spend a little time in the Ellenberg Park case, because it sets out the 4 tests. And you need, when you're drafting these things, to make sure that you meet these 4 tests, or else, but there are other things you can do, but that's the starting point. Okay. So the Ellenberg Park case is a decision of the Court of Appeal in England. It occurred in around, I think, the 1950s. But what it was, there's a place in England called Weston-super-Mare, which is on the ocean, and it's a sort of party town. And back in the early 1800s, mid-1800s, somebody was developing like a subdivision of estate lots. And what they decided to do was have a lot of house and no property. We're all used to that now in our development schemes. And so they had a large parcel of land, about 3 football fields in size, in the middle with the houses around it. It was like it was a square with the ocean on one side and the houses on 3 sides of it. And what they did is they gave to each of the homeowners a right to use the park. And they put an obligation on the owner of the park, who was also the developer of the project, to maintain the park and to create ornamental shrubs and to have benches and things like that. So each of these homeowners over a 100-year period, when they acquired their property, acquired a right to use this common area as a park. And there was also an obligation to pay your share of the costs. The people who owned the subdivision originally, the guy died, his trustees and his will, his trustees took it over. Interesting enough, sometime in the 1940s, the British government basically took over the park for military training purposes. And as a result of that, there was substantial damage done to the park, to all of the trees and things like that, as soldiers are wont to do. So the British government then paid compensation to the trustees, the owner of the fee simple in the park, for all the damage done. And these trustees, this has been in place for 100 years, decided they weren't going to use any of those funds to repair the park, that they were getting no benefit. It was the last asset of the estate. And what they really wanted to do was sell the park to somebody to develop it. And so an application was brought to determine, one, whether the owners of the houses had any interest in the park whatsoever. Did they have easements, or was it just a personal right to use the park, which died when the owners of the property died or when the property was transferred? And did the trustees have to use the proceeds received from the British government to maintain and repair the property? So that's what the case was about, and the court decided that yes, the homeowners did have an easement over the park, and the monies were to be used for bringing the property back into good standing, which is the right result. But in the interim, what the court did was went through right back to the basics of easement law to figure out whether these rights constitute an easement. And the court said there are 4 tests, 4 things you have to meet for an easement. Number 1, there has to be a dominant tenement and a servient tenement. Number 2, the easement has to accommodate the dominant tenement. Number 3, the owner of the dominant tenement and the owner of the servient tenement have to be different people. And number 4, it has to be the kind of right that could have been contained in a grant. It has to be a serious right. So in the Ellenberg Park case, the first part, the dominant and servient tenement, wasn't an issue. There were homes that had the benefit of this right, and there was a servient tenement, i.e. the park. So they wouldn't have to worry about the first one. But in the interim, there was, or in the decision, there was some discussion about this concept of having to have a dominant and a servient tenement. Obviously, a servient tenement isn't a problem because there's obviously the right has to go over something. It's whether there's a dominant tenement. And the issue is, well, what happens if I give you, I sell you a piece of property, and or what happens if I give you a right to use, my backyard for picnicking if you want to do so? Well, there is no benefiting land. It's just a personal right that I've given you to use my property. That will not constitute an easement. So where does this come up? There's one case where there's a canal, and they give somebody the exclusive right to use, to have boats for rent on this canal. And then somebody else, then they decide to sell additional rights to somebody else. And the court says, well, sure you had the right, you had a personal right to have your boats there, but there's no dominant tenement. It's not an easement. It's not something that runs with the land. There's a couple of very interesting cases in the Ellenberg Park case, partly of historical interest, but partly because of the facts of the case. One case dealt with Stonehenge, and Stonehenge had a bunch of roads running through it, and people, the neighbors for 1,000 years had their picnics at Stonehenge and used these roads to get into Stonehenge. And then the owner of Stonehenge decided that he was going to fence off Stonehenge and charge admission to the site. And so the local municipality or somebody brought an action to say, well, we've had easements for 1,000 years, a right to use these roads for 1,000 years. You can't do this. And the court said, among other things, there's no dominant tenement. The people using it don't have, this doesn't benefit any particular lands. It's a personal benefit in nature of a license. The other case, another interesting case, was a St. Andrews golf course, the most famous golf course in Scotland. Well, back in the 1700s, the local municipality that owned the St. Andrews golf course sold it and a bunch of other land to one of the local barons on the understanding that they would allow the people of the town of St. Andrews to use the golf course. Which was fine. What happened was the baron then rented out the property to, unfortunately, an Englishman who wasn't happy with the local rabbits that were normally raised in Scotland, and brought in a bunch of English rabbits. And the rabbits, they use the word infest, infesting the lands, and were digging holes and running around the golf course and doing awful things to the golf course. And so the people in St. Andrews decided that that they had the right, because they had a right over the golf course. They had a right to make sure that it was taken care of and protected. And so they brought an application to have the man's rabbits destroyed because it was wrecking the golf course. And this is these cases often have some very interesting, from a litigation point of view, very interesting facts. In the middle, between the time the decision was originally heard and the time the Court of Appeal made its decision, just like in the Frankenstein movie, the local politicians got the entire community of St. Andrews together with torches and guns and went out and killed all the rabbits that the person had on the golf course. And the court was not too impressed with the self-help remedy. So what they decided so what the court eventually decided was, no, there was no dominant tenement. These people, the members of the town, the golf course didn't benefit their lands. It was just a personal right that they had, and therefore they had no right to go on the property and to protect the property. So there's that case. And there's another case mentioned in the Ellenberg Park case dealing with a similar idea. It's a race track. And again, the court said that, you know, yeah, you had a personal right to use the race track once a year for your horse racing. You've done it for 500 years, but there's no dominant tenement, so it's not an easement. Okay, the other significant issue that comes up in the dominant servient tenement concept is what can constitute a dominant tenement? Is it just a fee simple interest in adjoining lands, or could other things constitute a dominant tenement? Can a leasehold right? Can a tenant be given an easement to benefit the tenancy over adjoining properties? And the answer to that is yes. Could a mortgagee of adjoining properties obtain their own easement over the servient tenement to benefit their mortgage interest? Well, to the extent that the mortgage is an interest in land, probably that would be a proper dominant tenement. Can another easement be a dominant tenement? Can you have the various easements tied together to get yourself to the dominant tenement? And the answer to that is likely yes as well. Obviously, personal rights could not be dominant tenements. So there are some issues there which that I've dealt with in more detail in the paper. Big issue, you know, in dominant tenement areas, the utility easements, you know, where they have these pipes, you know, it's to benefit the pipes going back to the head office of the institution, you know, like, you know, the courts look the other way on that, and because, I mean, it's, you know, it's not at all clear that those pipes, which are personal property necessarily, could constitute a dominant tenement, but that's sort of stretching it. What happened to my 6-minute warnings? Left, or to the next 6-minute warning? Okay, I'm going to speed up just a little bit. In the Ellenberg Park case, the accommodation issue was a big one. Does this park accommodate the freehold? And the theory here is that it has to be the kind of a right that benefits the real estate as opposed to benefiting the use of the real estate or benefits the people owning the real estate. So, for instance, if I gave you as part of your acquisition of a building a membership or the right to get a membership in a local golf course, that's a personal benefit to you. It may make the land more valuable, but it doesn't really, you know, benefit the land itself. In the Ellenberg Park case, in the Ellenberg Park case, the court said everybody has gardens attached to their homes. They don't have them in this case because of the communal park. Therefore, the communal park accommodates the real property. In the materials, I've got a list of sort of tests for accommodation, which you'll find helpful, but I won't go through right now. There has to be two separate owners, dominant servient owner. This may be the law of merger. It may be just an incident of easement law. Those two issues are important because merger is something that you can contract around, but if it's a legal doctrine of easement law, you can't contract it around it. There's a section in the Conveyancing Law Property Act that says you can do to yourself anything that you could have done to a third party when it comes to conveying real property. So one might argue that that you could therefore use that to get around that concept, but that's still an open issue. There's in the materials I talk about whether what the difference between dominant and servient owners, whether that means mortgagees, co-owners, partners, how all that fits together. The last test in Ellenberg Park has to be the subject matter of a grant. In the Ellenberg case, they argued that the right to walk around in the park was too vague, that you couldn't have put that in a grant. And the other thing is you can't have a right which is merely recreational, and so that was one of the arguments, that this was merely recreational. And the third issue is that the right can't be such as to create joint ownership. So in other words, if in the Ellenberg Park case, they argued that I can't do anything with my lands. They're completely nullified because of this right. these people get to walk around the park, and I can't do anything with it, and therefore they really own the park. Therefore, it doesn't meet the test of that easement test. And the court said, well, you can still cut the trees down and remove the flowers, and you can walk over your own property. So it's not joint ownership. And this comes into play when you have pipes, because when you put a pipe in the ground, you're clearly occupying that piece of property the pipe is in, and the owner can't use the property the pipe runs through. So why isn't that joint ownership? The court sort of, again, turn a blind eye to that and say, well, you can use the balance of the land, so you've met that test. Okay. This really is tough, because there are all kinds of things, other things I'd like to talk about. Let me, somebody raised a question about reserving a right-of-way in a grant. Can you get around the Planning Act? You know, if you want to give a easement over part of your land, you have to get Planning Act consent. If you were to convey to somebody and reserve easements over the land you're conveying, can you get around the Planning Act that way? It's not totally clear, but my view is that you can get around the Planning Act by reserving a right-of-way in the deed. And the theory is you're not conveying property, as the Planning Act talks about. You're conveying less of what you own, because you're keeping certain rights to yourself, and therefore it doesn't fall into the Act. Sid asked me to just say something about easements, expanding the use of easements, and what are the rules and what are the concerns about that. So there's a case, for instance, where there's an easement given to somebody for to carry on a wheat business out west. They have a farm. And the owner of the dominant tenement is the farm, and this is a right-of-way over the neighbor's property. The owner of the dominant tenement, the farmer, converts it into a U-pick berry farm, and therefore millions of people start using this access to get to the U-pick berry. And the court said, well, now you've gone too far. You've changed the nature of the easement. You've converted it effectively from a single-purpose commercial use to almost like a public use, and therefore you've gone too far. Basically, the test is reasonability. The court will look at whether the increased use of the property is reasonable in the circumstances. Was it, reasonably contemplated? The other thing you should know is in easements is that you do get ancillary rights, so that if your document, it doesn't say exactly all the things that you ought to be having in order to make that use reasonable, the court will imply a certain ancillary rights. So for instance, if you have an easement to lay down pipes and you have to go over other parts of the property to get to the pipes to do repairs to lay them down, the court will give you ancillary rights over the other property, even though it's not in the grant. I'll talk about it just quickly about a couple of. I want to just mention the notice of claim issue. I was going to go through it in detail, but Section 13 of the Registry Act talks about the search rules, 40-year search rules. The issue is, what happens if you get, say, a mutual right-of-way over your neighbor's property, and you hold that property for 50 years? You're over the 40-year period. Do you still have a mutual right-of-way at the end of 40 years? And my view is on a reading of the law and the statute is no, you don't. You lose it. That once the 40 years goes by, you lose all your easements unless you've registered a notice of claim on the servient tenement to support them. Now, this is a very surprising and upsetting position for all of you, for a lot of you, I'm sure, because you probably don't, as a routine matter, register notice of claims for any easements whenever you're buying or selling property. There will be cases. There are cases in process now where this issue is to be determined. Most people feel that if you were to buy and sell a property, and you were to say, I buy the property together with an easement over the servient tenement, that would be sufficient to keep that easement going for another 40 years. The courts may very well find that's the case, because when it's a reasonable position, it's what everybody expects to be the position, and nobody's upset or fooled or prejudiced by that position. It is, in my view, it is not correct on the reading of the statute, and it is open for the courts to find that is not the case, and that you have to register a notice of claim. So I've dealt with that in the paper, and you might want to think about that as well. Last case is this a recent case, just for fun. It's called the Spartan case. The neat thing about easement law is that it's like a bunch of stories. And it's amazing that, what do they say, real life is truer than fiction, or whatever it is, that it's amazing how people can get into disasters, and in easement law, it's happening all the time because the stuff is basically not done right in terms of there's not proper grants. You know, people are friends, they buy property together, they give each other rights, they then die and their kids take over the property and their kids hate each other, or they get sold to somebody else who, you know, hates the neighbor, and all of a sudden the fights occur. So the Spartan case is a nice commercial example. There's a large parcel of land. It gets sold to ABC Co. And the person who sold it, Spartan, allows the neighbor to have an easement over his land. So Spartan is the servient owner, and the dominant tenant, the dominant owner then builds a shopping center, believe it or not, a shopping center on the property, and his only right of access to the shopping center is over Spartan's property. The document granting the easement has a contribution for costs for lighting and road repairs and insurance in favor of Spartan. So Spartan's spending money. It's got this dry road over its property, and it demands that the shopping center owner, you know, reimburses it. The shopping center owner couldn't care less because they get it all back from the tenants anyway. Except that there's absolutely no way the shopping center owner can figure out what is being asked for, what's being charged. The demands for payment come in years later, in which it's too late to charge it back to tenants. So it's a real mess. And so the shopping center owner doesn't pay and says, I need reconciliations. And so and again, this is the problem with the self-help. The Spartan who then says, well, then I'm terminating your right to use the property, the access, and proceeds to park trucks, dig holes, put fences, everything you can do to try to block the access, forcing the shopping center owner to go to court and get an injunction. And the court is not too happy with the servient tenement owner for doing this. And the court basically finds, and I think is right in law, that the easements are valid, but the positive covenant to share costs does not run with the land, and therefore does not bind the owner of the shopping center, who is a new owner. So in other words, there has been a second transfer. So there's no direct contractual relationship on the positive covenants between the shopping center owner and the servient owner. And so the court says the easement's valid, you can use the easement all you want, and you never have to pay a cent. And that seems to be the law. The Amberwood case supports that position. Now there's a case called CIBC in Stanton, which you may get around that. What you need to do in your easement document, if you have positive covenants, is to provide charging language, provide that any purchaser has to assume the obligations directly with the servient landowner, and those things would protect you. There's a lot of other stuff in the paper, and thank you very much for your patience.
Just a reminder to do your evaluation forms as the afternoon proceeds. When I was a much younger lawyer, I knew only one thing about commission slips, the little bit of stuff on the agreements of purchase and sale. I was taught that they're tricky because they always say the consideration or the commission was payable for procuring the offer. So the one thing I always knew to do was to change that to always add that the commission was only payable provided the deal closes. I don't think in the last 30 years since I was called anybody has made any significant review of listing agreements and commission slips. Ira Barkin from Goodman's is going to spend the next 15 minutes telling us some things about commission slips.
Thanks, Ed. I think it was Jerry Seinfeld who said, it's always tough to go on stage following a talk on easements. If your practice is anything like mine, you don't often become involved in agency and commission agreements, and sometimes that's too bad because the issues and monies involved can be significant. However, every once in a while, you may be asked to review an agency and commission agreement, sometimes in advance of it being signed, if you have maybe a very prudent client. and sometimes, unfortunately, if a dispute arises. So the purpose of my talk today is to highlight, hopefully in a practical manner, some issues you and your client should pay attention to, and in so doing, hopefully avoid some of those disputes. I would like to stress the word practical. I think the presenters at this summit have been trying to present issues in a practical and less theoretical way. And so a practical word of advice, don't try to revise a standard form commission agreement in a residential real estate context. The reason for this is at least twofold. The realtor industry perceives standard form residential agreements as providing carefully constructed limits on their liability and a fair deal to both parties. And secondly, it's usually not economical for lawyers to engage in any kind of negotiations based on the relatively low fees residential vendors are willing to pay. So what we're really talking about today are commercial agreements. And in terms of commercial agreements, we're really going to stay away today from the leasing issues. There are a myriad of very specific leasing agency and commission agreements that were well spoken to by Mr. Goldenberg in a 1999 paper presented here at the 6-Minute Commercial Leasing Lawyer, and I've given you a cite for that in the paper. Listing agreements, I'm using that interchangeably with agency and commission agreements. Agency and commission agreements, it's a bit of a mouthful. For the purposes of brevity and clarity, we really should be talking about listing agreements, because a lot of people who've analyzed real estate agents and their practice really don't consider them agents at all. Agents typically possess the ability to contractually bind the principal. And there's a certain independence in decision-making that agents have. You're really not going to find that to be the case in most real estate transactions. After all, the vendor's going to know more about the property than the agent. Principals are often said in a principal-agent relationship to be vulnerable to the actions of an agent. It's not as true in a commercial real estate setting. So brokers, realtors, they're not agents. They really facilitate the bringing together of a buyer and a seller, and that's what their commission is meant to compensate them for. So in comparing a model agreement, which I've prepared, and you'll find it at the back of the materials, hopefully you'll be able to show your client what some of the major issues are when going through one of these agreements. And in so doing, I've categorized the comparison really along 4 objectives that you'll find in many commercial agreements. From the realtor's perspective, it's to maximize profits by ensuring a favorable commission rate and structure, to maximize the opportunity to profit, and the realtor does this by setting a flexible commission trigger, by minimizing duties, liabilities, and expenses under the contract, and the realtor does this by inserting limitations on liability and indemnification clauses. And lastly, the realtor wants to ensure certainty and enforcement, and they do this by making the commission easy to extract. I've put in chart form, I'm going to refer to that now, the comparison between the model agreement that I provided and the standard form. The model agreement, just as a word of warning, it's not meant to be exhaustive. It's really meant to provoke thought and to highlight certain issues that you want to go through with your client. It's not meant to be a realistic or representative sample of what you'll end up negotiating with your realtor, but it's a good starting point. The standard form agreement, what I'm referring to there are really the OREA form, the TREB form, and they're remarkably similar. So maximizing profits, let's talk about the commission. In the model agreement, I say the commission is on the cash portion of the sale price. Standard form agreement says it's on the entire sale price. Well, where can the distinction arise? Most notably, I would say it was with vendor take-back mortgages. You may have an awfully disappointed client if at the end of the day all they can get for their property is a purchase price based on, suppose, a 95% VTB. 1 year later, the property may be back with your client and they've got to pay a commission again. So one of the things you may want to say to your client is, when negotiating these agreements, you're not going to pay commission on the VTB portion of the sale price. Now, a lot of realtors will say, well, good luck to that, but at least it's a starting point of a negotiation, and you may get some realtors to pay a smaller percentage of their commission on the VTB portion. I want to talk to you about another structure issue because it came as a complete surprise to me, and I canvassed a lot of my colleagues, and people really weren't aware of this rule. But under Section 34, Sub 1 of the Real Estate and Business Brokers Act, it is not lawful to charge a commission based on the difference between the listing price and the sale price. So let me give you a practical example. You've got a client, And the client would be thrilled if they could get $1 million for the property. And they say, you know what, I want to incentivize my broker. I want him to go the whole 9 yards. I'll pay him 4% up to $1 million, but if he can achieve a higher sale price, well, I'll pay him 5% on anything above $1 million. You can't do it. There's a new Real Estate and Business Brokers Act that has not yet been proclaimed, and when it does, it will modify that section, but you can only charge a lower percentage on the differential. So again, to use that example, $1 million, you're going to pay 4%. You can then offer anything above $1 million for the up to the ultimate sale price. Above the listing price, you can do 2% or 3%, but you certainly can't do it higher than the original commission. It's meant to be consumer protection legislation. I can see in certain instances an unscrupulous realtor taking advantage, but I was kind of surprised because, in fact, I think I've seen commission agreements. I can't pinpoint them, but I'm sure I've worked on them where there's been a higher percentage paid on the differential between the listing and the sale price, and it's not onside the law. The commission trigger. I've gone to great lengths to say that you're going to pay commission on the successful completion of the sale of the property. The standard form agreement, much to your client's chagrin, does say, for clarification, commission is still due if non-completion is owing or attributable to the vendor's default or neglect. I don't think you want to get into whether a deal didn't close because of vendor's default or neglect. You may be faced with that anyway. Why give the realtor a leg up? Holdovers. If you're going to be involved in a dispute at all, it's probably going to be with this clause. It's just human nature. Vendors, if they're not getting along with their realtor, will try to wait out the listing agreement period and try to beat them out of a commission. Well, you just want to have clarity here, and I think one of the ways you can do that is to say, number one, during the holdover period, you're not going to get a commission unless the sale is actually completed. It's also helpful to say, if you want a holdover commission, it's got to be based on a purchaser, not only that you may have introduced to the property, but that's listed in a specific list that the realtor will file with the vendor before the closing of the listing period. And lastly, you may want to limit the number of holdover candidates that would be subject to a commission if the sale is completed. I've suggested 5. Again, a lot of realtors won't go with that, but again, it's really meant to provoke a discussion and to highlight something to look at. Minimizing duties. Let's talk about the realtor's obligations. The standard form agreement does not include any substantive obligations on the part of the realtor. They say they're going to be your agent. Well, so what? Why not put in the specific duties that can avoid a lot of disputes down the road? What do you want your realtor to do? Spell it out. It's that simple. I've put in a few in the model agreement, such as keeping good financial records, producing weekly progress reports. Your realtor may say that's fine, so why not put it in? That way there's no misunderstanding. With respect to liabilities, the standard form agreement says that the realtor's liability is limited to gross negligence or willful acts. I wouldn't worry too much about that. The standard form puts more liability, the model agreement puts more liabilities on the part of the realtor, but the realtor is already subject to a myriad of obligations depending on what organizations that the realtor belongs to. The standard is not, at the end of the day, likely to be gross negligence. Property warranties. There's a case law that's back and forth, and it's not at all clear as to whether you can read a listing agreement in conjunction with the purchase agreement, and to the extent that they don't interact very well, you may read in certain provisions in both. If that happens, you may be faced with a situation, your vendor may be faced with a situation where it has made some representations and warranties, say in the purchase agreement, that the realtor could become liable for because everybody's going to start suing everybody if something goes wrong. Now, most real estate transactions today are as is, where is sale. So why not make that clear in your listing agreement? And if you do that, the realtor should be on its own. If it wants to puff up the property, it's their duty bound to put in their own disclaimers, but as vendor, you shouldn't be offering anything that comes close to a rep and warranty in terms of the quality of the property. And the way to make sure is to make sure that both the listing agreement and the purchase agreement are as is, where is deals. Buyer beware. Buyer's got to do all due diligence. Lastly, on enforcing payment, the standard agreement says that the deposit, if it's forfeited by the purchaser, even if the deal doesn't close, the realtor can have its commission, or at least to the extent that it actually expended monies. The model agreement that I've prepared doesn't have that. The deal is the deal, and that's that you get, the commission is paid on successful completion. That means title is transferred, monies are exchanged, all escrow conditions have been completed. So I hope the paper and this little talk today has given you some things to think about should you, and again, it won't be very often, encounter agency agreements. And I thank you for your time.
Thank you, Ira. Our last speaker for this session is Jeffrey Lem, who is going to spend 20 minutes, so that we're on time, maybe 18 minutes, 17 minutes if I stand here long enough, telling us what happened to the Cummer Young case. Jeffrey.
2 words: performance anxiety. Some of you older gents in the room will understand what I'm talking about, but I have performance anxiety all the time, not just at home. I come to work, I have performance anxiety. My partners demand a lot of me, my clients are even meaner towards me. On top of all that, I have to please guys like Troister. You don't understand what the CLE circuit's like, you know. You have to beg to get a job at the podium. So it's, please, Sid, pick me, let me be the one. And on top of that, they give you the topic. It's not like I get to pick the topic. They say, yes, today you're the one. You're on the A team, but here's your topic. My biggest fear as far as performance anxiety when I speak is that I get a boring topic. Nothing turns on the speaker, it's all the topic. The topic sells the day. First thing he does, he says, I'm going to give you the Crystalline case, which is a sort of take on Cummer Young. And I go, oh my God, Cummer Young, how many times have I done that? This crowd is going to tear me apart because that is one boring topic. And I was really quite afraid of having to approach this crowd until I looked at actually the rest of the agenda and I saw like somebody was doing like interesting cases in easements. My God, I am going to be okay, right? This is going to be easy. Supreme Court of Canada, the case is called Crystalline. I'm going to cut right to the chase on what Crystalline did. Crystalline killed Cummer Young. For 40 years, we have had a rule in Cummer Young. Cummer Young, succinctly put, says that if you have a landlord and tenant relationship where the landlord also has a guarantee of the tenant's obligation, if that tenant goes bankrupt, the landlord may or may not be able to pursue the guarantee. In Cummer Young itself, it was a pure guarantee situation, and the judge held if the tenant's obligation dies, so does the guarantee. So that is Cummer Young in a nutshell. Over the course of 40 years, we have had dozens of permutations of Cummer Young. Well, if I don't use a guarantee, maybe I'll use an indemnity. Sometimes it worked. Recently, it hasn't worked. Well, if I don't use an indemnity, maybe I'll use a letter of credit. Sometimes it worked. Recently, a bunch of cases said it didn't work. So for 40 years, we have had pure anxiety over whether or not a landlord, if a tenant goes bankrupt, has any remedy against any sort of surety, okay? Now, with the decision in Crystalline, all of that is finished. We no longer have anxiety from a Cummer Young type argument. So it used to be if somebody said, well, am I going to have any success, I, landlord, suing that guarantor now that the tenant's bankrupt? I would say 50-50, depending on how things are worded. And that's the best I would ever give you, 50-50. You can pay me a ton of money at my billing rate, and I'll tell you 50-50, right? Now, it's a much simpler analysis, okay? There is no more Cummer Young threat. Now, that's not to say that it's all of a sudden 100-0, because as we all know, with any surety arrangement, I don't care if it's a letter of credit, indemnity, deposits, letters of credit, there are still dozens and dozens of equitable defenses, right? So I'm not saying that all of a sudden it's 100-0. All I'm saying is we never worry about Karr anymore, and it's just an analysis of pure equity, okay? So that's what Crystalline did, okay? And I could actually end my speech right here, because you're going to go back to your office and know that you're never going to have to worry about this. The second question you're going to ask me, though, practically speaking, why do I care, okay? Now, we all have our, I think everyone now uses probably an indemnity agreement. I think a lease guarantee is probably a dodo. I don't think anyone ever uses a guarantee anymore. At the very least, you use an indemnity agreement, right? So what do I do with that indemnity agreement? It has all sorts of pure anti-Karr type clauses. And you know the clauses I'm talking about. This indemnity shall survive any bankruptcy of the tenant, disclaimer of the lease, blah, blah, blah. In the event of a disclaimer of the lease, the indemnifier will typically enter into a lease for the balance of the term at the usual rent. Those types of clauses. Well, what do I do with them? Crystalline says Karr is useless. It's not part of the law anymore. What do I do with those clauses? Leave them in. I'm going to leave them in. I worked hard to develop those clauses. Even though Karr is gone, those clauses don't hurt you, so leave them in. On the other hand, if some fresh kid straight out of bar ad said, I've got a landlord-tenant arrangement, I want a guarantor of that tenant, and I grabbed O'Brien's commercial guarantee, you know, just one from a bank deal or any sort of a simple form guarantee with none of those special Karr clauses, will I be all right? Yeah, you'll probably be all right. Crystalline says Karr is not a problem anymore. So the bottom line is, if you have existing precedents which are structured around Karr, let them be. They don't hurt you. Let them be. If you have young people and they're starting all over again and developing it, I honestly wouldn't worry about trying to put those type of Karr clauses anymore. So that's what Crystalline did. I'd like to spend a few minutes, however, actually going through the Crystalline case because, one, there was a very interesting argument that was raised in Crystalline, and it could have some really cool implications for your landlord clients, okay? So to do that, you have to bear with me. I'm going to have to go through the Crystalline facts, but I'm going to distill the facts down to really what you need to know. Crystalline was the coolest application ever of Karr. Here's what the deal was. Landlord, tenant. Tenant decides to assign the lease. So now you have landlord, assignor, assignee, okay? Common law 101, assignor stays on the hook, right? We all know that, unless there's a specific release, and there isn't a landlord who's brain dead enough to give a specific release. So, typical arrangement, assignor stays liable. Assignee usually signs one of those, what do they call them? Tri-party agreements. Like, that's very descriptive, right? A tri-party agreement saying that it will also be bound, right? So the landlord typically ends up with two covenants, okay? Now, here's what happened. Assignee goes bankrupt. Landlord goes and claims what he's entitled to in a bankruptcy. What's he entitled to in a bankruptcy? 3 and 3. 3 months arrears, 3 months accelerated if provided for in the lease and if there's enough chattels on the premises, okay? So let's say it's 6 months. That's called the preferred claim in bankruptcy. Most landlords get 6 months, okay? So the landlord, you know, the assignee's bankrupt, does it all officially. The landlord goes in, gets a check for 6 months and says, okay, now I've got 6 months worth of rent. I've got my premises back because the assignee, you know, the lease has been disclaimed. I've got this tenancy here. But you know what? It's a dog's property. I'm never going to release it. I've got tons of damages. This 6 months barely covered my legals, right? Well, with me, it's probably barely covered an hour of his legals, right? But landlord says, I still got a ton of damages, like real damages. Like, I'm not going to relet this place, right? So what am I going to do? Well, didn't I remember Common Law 101? Assignor remains on the hook. I never released them, right? So he phones up the assignor and says, Mr. Assignor, do you remember that lease you signed? You were a tenant, remember? Landlord, tenant. I covenant to pay tons of rent for a long period of time, right? And I never released you from that, so please make up the difference, like 12 years worth of rent or whatever the number was, right? Assignor's kind of dinged. He's saying, oh, damn, I don't want to pay that, right? Assignor phones a very probably prominent lawyer, and he says, find me a way out of this. So let's presume this prominent lawyer says, what's an assignor? Okay? Isn't an assignor sort of like a guarantor? Like, you know, the lease has gone over to an assignee. The assignee makes regular payments. If the assignee misses a payment or two, you know, you might get a phone call and you have to make up the payment, right? Isn't that what guarantors usually do? In fact, I'll bet you that the court will buy into the argument that an assignor is a de facto guarantor. Now, that in and of itself doesn't help you a lot. You know, guarantors have to pay money, assignors have to pay money. But it does help you if you've got cum or young, right? Cum or young plus guarantee equals release, right? So that's exactly the first argument in Crystalline. Excuse me, we are a de facto guarantor. We might as well have been a guarantor. And if we're a guarantor and there's cum or young and the tenant has gone bankrupt, well, guarantor is off the hook. Supreme Court would not buy that one. Longish analysis, but we kind of, like everyone in the room knows that that one wasn't going to work, right? Although I've used that one before, but we all suspected that Common Law 101 would win on this one, right? There was direct privity of contract. You can't just by assigning the benefit of your lease all of a sudden become a secondary obligor and attract equity to you by something that you did, right? So I kind of knew, everyone kind of knew that that argument was not going to fly with the Supremes. It's the second argument that they used that was both clever and has a lot of repercussions. The second argument, well, you know, you can already tell they knew they were going to lose the first one. So they said, in the alternative, I love the way these litigators talk, in the alternative, let's understand, first of all, what bankruptcy says. Bankruptcy is passed by the feds. It says that a landlord should get upwards of 6 months, full stop, okay? Is it fair? Who cares? That's what the legislation says. Bankruptcy in itself is not a fair thing, right? Some people get compromised. That's the way, you know, there was a judgment call made by legislators around the world, too. There's bankruptcy legislation around the world that at a certain point, a debtor gets off the hook, and some people get burned in the process. And the Canadian legislation says landlords are amongst the burnees, and their compensation, though, is the 3 and 3, 6 months, okay? And that is a policy of the federal government, right? If you allow the landlord to sue the assignor, or any surety, right? Like, let's say it's an assignor or guarantor, however, or whatever, for 100 cents on the dollar, 10 years worth of rent as opposed to 3 and 3, 10 years worth of rent, right? And if you allow this to succeed at trial, what do you think that guarantor is going to do? Just sort of roll over, here's your check, have fun? They may pay, but immediately they're going to file a claim in the bankruptcy. Why not? At law, most guarantors, first of all, as a matter of common law, has a subrogated right. Like if I pay off somebody's debt, I'm subrogated to the creditor's rights against that person. Right? Even without that, most indemnity agreements have like contractual subrogation rights. So in other words, if I pay your debt, right, I will recover from you what I had to pay for you. If I cover your loan, or if I cover your debt to the landlord, I will turn around and get the money from you, right? That's fair, and it's supported both at common law and in most contracts, okay? So here's what's going to happen. Landlord is going to sue the tenant's estate, but he knows he can only get 3 and 3. He's going to have some leftover damages. He's going to sue a surety, and I don't care what kind of surety it is, and he's going to succeed, right? If he succeeds, that surety is going to turn around through the back door and file a claim for 100 cents on the dollar, 12 years worth of rent against the trustee in bankruptcy. And then somebody said, well, how can that possibly be the law? Didn't the feds say landlords equal 3 plus 3? Right? In other words, if I was a trustee in bankruptcy, I would do a budget, right? A budget would say, this tenant or this person, this entity has gone bankrupt, and I, as a trustee in bankruptcy, now have to budget what I have to pay out to various creditors, right? Secureds will usually take the whole pile, or almost the whole pile. I have a few prefs. I know the landlord's 3 and 3. I'm going to budget that, right? And if there's anything left over, it's my duty. It's a fiduciary duty to spread it X cents on the dollar to the unsecureds, right? So all the unsecureds are going to line up there, and I'm going to give them, you know, whatever, 10, 20, 30 cents, more or less, whatever, on the dollar, okay? And I've got this budget in my mind. Secureds are easy. I phoned the mortgagee. I said, okay, bank, how much do you want? The prefs are very easy because they're all prescribed by statute. Right? So I have budgeted 6 months for the landlord. All of a sudden, okay, and I pay the landlord his 6 months, all of a sudden, a surety comes in and says, you know that lease, the lease that you budgeted 6 months for breaking? Yeah, well, I had to pay out full freight, 12 years worth of rent on that lease. I'm lining up as an unsecured. So whereas before I used to have 30 cents on the dollar for the 5 or 6 unsecured guys who are left, the poor suckers down at the bottom of the pool, I have another big fat landlord joining the back of the lineup with a 12-year claim, swamping it. So 30 cents on the dollar has now gone to 3 cents on the dollar, and the landlord gets a second level of recovery. Okay? That was the argument before the Supreme Court. The assignor said, "My lords, how can you let this happen? Because if you allow my client, the assignor, to get sued, we're going to turn around. I mean, the next day, I've already got it drafted. I've got a proof of claim. I'm going into the trustee in bankruptcy, and I'm going to swamp the unsecured creditors, right? So your call, like, are you going to allow the federal government to be trumped by common law 101? Now, so poor Mr. Justice Major is struggling with this issue. This is the cool issue, okay? And I've got to sort of figure out how he's going to decide this. Okay, I'm pretending I haven't actually read the decision yet, right? So how's he going to decide this? Right? There's a doctrine of natural justice which says that you're supposed to intervene, the law is supposed to intervene at the place closest to where the problem exists. Let me give you an example. If society adjudges that treason and sedition amongst lawyers is a bad thing, it should punish treason and sedition amongst lawyers. So if you and I have a conversation and say, let's overthrow the Liberal government, right, then we should be arrested, right? Overthrow illegally, right? But the law should be that we cannot have a conversation plotting to overthrow the government. That's what the law should be. It should not be lawyers should never gather in a group, right? Although it's mildly logical too. If lawyers never gathered in a group, they would never have an opportunity to be seditious, right? And at first that sounds like a ridiculous argument until you bring it very close to home. Human beings think like that all the time. As you well know, I have a 14-year-old daughter, okay? She's going to go to high school. She says to me, "Dad, I want to go to a public high school." "Dad, I want to go to a public high school because of 2 reasons. I like boys, and I want to wear street clothes," right? Now, where's the crime? Inappropriate conduct with teenage boys is a crime in my book, okay? So really what I should do is impose a rule, right? Even if I let you go to a public school, you are going to adhere to my code of behavior, which means nothing even approaching boys. Instead, as a lawmaker, I decide to go one better. I'm not going to stop the problem here. I'm saying you're not going to go to a public school at all. I've got you lined up at this private school that has uniforms and no boys, right? So my solution is one step up. I'm going to force you not to go to a public school. The rule is you cannot go to a public high school because you might incidentally then meet boys, right? Now, let's take it right back to the Supreme Court of Canada. Mr. Justice Major has 2 choices, right? I'm not going to let this assignor get sued because if he gets sued, it might then present a claim in the bankruptcy of the tenant. Or he can say, go ahead, sue the assignor, but if the assignor ever brings that claim, that's where I'll stop it, okay? Now, of the 2 choices, he picked neither. He said, I don't care if you sue the surety, the assignor. Go ahead and sue them. They should be sued, okay? Common law 101. And instead of saying, I will stop the claim from the assignor into the estate, he said, I don't care if the assignor sues the estate. Why shouldn't he? Go ahead, sue the estate. What I think has been lost in the translation is all of a sudden what used to be a six-month claim that a trustee could always count on for a lease has now been theoretically blown proportionately way out of whack, because any surety that gets sued now seems to have a free ticket from the Supreme Court saying, come on in and file a claim as an unsecured creditor. Up until now, the law has been a landlord gets 3 and 3. There's case law to say you never line up as an unsecured. Once you get your 3 and 3, you're done at the dinner table, you're out. It seems to me that the Supreme Court in Crystalline has now opened that wide open. Why do you care? 9 times out of 10, bankruptcies do not, your landlord could care less about a bankruptcy. By the time the secureds get through with the estate, there is nothing left for the unsecureds, right? Even the legal fees of trying to line up for 2 cents on the dollar is not worth it, right? 1 time out of 10, it might make a difference. So you can line up now as an unsecured, and also there's a lot of political advantages now. You're going to be able to swamp the other unsecureds, you're going to be able to cut deals, you're going to have influence now. Also, one final potential example. Imagine the following scenario, okay? Say you wanted to be clever and you wanted to make sure, so again, Crystalline allows you now to sue a surety, but it also allows you to come in as an unsecured. So this is a double whammy. Crystalline has really opened the door for landlords. What if you wanted to get really clever? Me, landlord, 1 giant head lease for every one of my 400 shopping center units, okay, to Tenant Co., conveniently a subsidiary, okay? Tenant Co. then starts assigning leases one by one. So as the mall fills up, it's one by one. So what kind of a relationship do we have now? Landlord, assignor, assignee. Ooh, sounds like crystalline, right? Tenants start going bankrupt, right? All of a sudden, whether or not I have a surety, right, my subsidiary assignor, I'm going to sue the assignor, okay, fine, whatever, right? They're going to settle with me, but the assignor, my subsidiary, now lines up in every single tenant insolvency, right? Potentially clever, right? Potentially clever. Ladies and gentlemen, thank you very much for your time.
We'll take a 15-minute break, and then we will watch 4 or 5 of us fight and talk about what to do when deals start going south. Thank you.